Good afternoon, everyone. My name is Brenda Imelda Makoha. I am an advocate practicing in Kenya, and I'm also a member of the East Africa Law Society Young Lawyers Committee. And I welcome you today for our monthly webinar series. This is our first webinar for the year, so Happy New Year to everyone. And our topic for today will be election laws and practices, a roadmap on the election processes and disputes in East Africa. We have 7 panelists today. On call, we have Mr. Julius Galisonga. We have Mr. Aston Steve Nimubona, Mr. Rich Maluel, Mr. Moses Kipkoge, Mr. Jebra Kambole, Mr. Alfred Locke, and Mr. David Rugaza. So some of the panelists have not joined in, but they will be joining us shortly. And in the interest of time, I want us to start. So Mr. Julius Galisonga will be our first presenter. He is a senior advocate of the High Court in Uganda and is one of the leading constitutional and electoral lawyers. And he has previously worked with the Electoral Commission of Uganda as the district election officer. Karibu sana, Mr. Julius. The floor is yours.
Asante. Good afternoon, everyone, and Happy New Year to you all who are listening in and participating in this seminar. Julius Galisonga, as introduced by the moderator, and I'll only speak about what is required of an advocate to ably prepare to prepare and execute an election petition. What is an election petition? An election petition is a process by which results of an election can be challenged in court. And taking the example of Uganda, there are several laws that govern and moderate election petitions, depending on the kind of election. For example, if it's a presidential election, there is, of course, the Constitution of Uganda, there is the Electoral Commission Act, there is the Presidential Elections Act. If it's parliamentary elections, there is, of course, the Constitution and the Electoral Commission Act, and of course, the Parliamentary Elections Act. We have local governments, which are at district level. In Kenya, you have provinces or something like that, where you have governors. A governor in Kenya, in Uganda, is a LC5 chairperson. That is local government in Uganda. So you must appreciate, first and foremost, what law is guiding you in the election petition that you're seeking to present. Why is it important to familiarize yourself with the laws, or even to determine the particular law that you're going to proceed under? One, because each law specifically provides the grounds for which a person can present a petition and the grounds on which court can set aside, nullify, or in any way deal with an election petition or an election. So you need to understand why, because the timelines are different. Whereas the Presidential Elections Act, for example, sets 10 days within which to present a presidential elections petition. Parliamentary Elections Act provides for 30 days. Why is it important? Because if you do not follow the timeline, for example, elections are very important in any country, and all courts have agreed on one thing about why it's important to determine election petitions in time. Why? Because the people who are governed, the citizens in every country, should be able to know their leaders in time and to calm down the nerves. Imagine right now the hulabaloo that is in Kenya, the tension, the excitement that is in Kenya. Assuming This goes on up to August when the election is going to take place. And then another 9 months go on without, after an election petition has been filed, without determining that election petition. It will leave the country paralyzed. And of course, even the incoming president will be greatly inconvenienced in proceeding and starting his work. So it's important that you know the law under which you're going to proceed. That will guide you on questions of timelines. It will help you on how to plead. You should understand that general civil procedure, disclosure of the cause of action, for example, auto garage versus motor code, is equally important in an election petition. You can put up allegations of whatever nature, but if you do not plead your case well, if you do not plead your petition well, certainly the effect will be that your petition is not disclosing the cause of action. And of course, that can be a problem when the petition is dismissed on a technicality. In Uganda, we had a scenario recently after the 2016 elections, when the presidential elections petition was filed by the Honorable Chamberlain. And certain things had not been pleaded well, and they sought to amend, the petition, they sought to adduce more evidence and affidavits, and the Supreme Court rejected that. Why? They couldn't allow filing new affidavits because whatever they were deponing to was not even included in the petition. Effect being, if you understand the law, you'll be able to do the right thing. But then, in Uganda or in any place in East Africa, for example, an election is a process. It starts with the time for even a person taking interest in contesting. It then follows the nomination. Then it follows the campaigns. Then after the campaigns, it comes to election day. So even during the time of campaigns, disputes can arise that can be resolved. For example, if a person was nominated when he's not qualified to be nominated, if the nomination had some defects, now those are all steps. And there is a popular case here, Omangime versus Winnie Yanima, where they say an election is like a river, it flows one way. It's not a dual carriage that vehicles are going north and south at the same time. If a step is overtaken by events, you can't come back. So it's important to know what steps you're taking at what point in time. And all of this is, as I've said, prescribed by the law. Take an example. Assuming the time for campaigns has been completed and the election is going to be conducted or has been conducted, can you, for example, complain to the Electoral Commission? In Uganda, the Electoral Commission has powers to regulate issues that are even to determine issues that arise during campaigns. Can you go to Electoral Commission and complain that candidate X campaigned beyond the prescribed time, maybe at 8 in the night, when it's past the time for, after the election has taken place? Of course you cannot. So understanding the law will help you determine which complaints you can bring at what time. It will help you in preparing your petition and the affidavits that support it. Because for the larger part, save after court has given leave, most times evidence is given by affidavit evidence. Now, can you, for example, bring affidavits over matters that you did not leave in the petition? So, as I've said, it's a process, and understanding how it runs will help you determine what complaints can arise and at what time, and even who determines them. Some matters can be resolved by the district returning officer. Others can be determined by the Electoral Commission itself. Others can be determined by a magistrate's court. Others, high court. Now, it will help you determine not only how to plead, but also the jurisdiction. But as I've said, an election is a process. meaning each understanding what happens at each process, at each point in time, at each level of the election process, can also help you in preparation. Why? Because in as much as you may not raise some matters after they've happened, they can help you in the election petition itself. Why? An offense committed during the campaigns can found a ground for petition. We have several grounds, of course, non-compliance with the law, and of course, committing electoral offenses. Now, these two are different. But an event that happened during the campaigns, it could have been non-compliance, but it could also have been an electoral offense. It can help you at the time of preparing the petition. It's important that as a lawyer, if a person desires to hire you to represent him or her at some point, because we always anticipate that it may result in conflict, maybe even for guidance, it's important that we start impressing the public or people who are participating in elections that a lawyer it should be involved right from the beginning. The same way a person runs to a doctor when he feels a headache, or when he suspects that he's getting, for example, a migraine, he doesn't want for the migraine to set in, he runs to the doctor. When you run to the doctor, you are able to arrest the situation, or even a chronology is kept, and whoever comes after to treat you can know where to start from. Same thing with elections. Most times people involve lawyers after the election has taken place, but most times a person hears rumors, so-and-so did this, so-and-so did this, but there is no evidence to support it. So it's important that we start impressing it on the public that a lawyer should be involved at whatever stage. When you go for nominations, ensure that your lawyer guides you on how, for example, the nomination papers are signed. If a person who is going to take that oath, because most times it is a notary public or even a commissioner for oaths who administers these oaths, there are certain allegations they make in the nomination papers that require to be witnessed by either notary public or a commissioner for oaths. A lawyer should be able to guide you whether that person is actually qualified to witness such an oath, because if there is a defect in the nomination, it can found a ground for appeal, for petition. If there is a problem in the, for example, during the nomination, the witnesses are not competent to be witnesses, it can found a ground for what? For petition, and also result in setting aside an election. So how do you avert that? Involve the lawyer, so that they guide you, or even to benchmark the performance of the other candidates. If it is not done, a time will come, because an election is too fast, there's always a lot that goes on. Imagine in Kenya, for example, I read the other day that the Honorable former Prime Minister had traveled days at Ethiopia or to India and is not in Kenya. How can he be able to track what is happening the other side of the divide, in the camp of the opponents? If you're not there, then be able to have the people have the ears and the eyes to bring the information, so that as a lawyer, you'll be able to keep a record of all of this, because it is this information that can then found the information that you put in the important to it, apart from getting knowledge of the events as they occur and helping you prepare as well. Most importantly, I've already indicated that there are strict timelines for the reasons I gave in when you can file a petition and when a petition can be prosecuted and concluded. Now, if you expect to start gathering information after the election, when a client comes to you and says, they told me so and so did this in Kiambu, then they went to Taita Toveta, did this, by the time you go even look for the witnesses who witnessed that, that is all time. And you may, if it's a presidential election in Uganda's case, you have only 10 days. You cannot travel across the country to gather evidence to meet the people. But if you gather evidence in time, even prepare drafts, say that when finally something goes wrong and you feel there is reason to file a petition, if you lost the election, for example, you have ready information which you can then compile very well and properly, then you put in court. Of course, a lawyer should be well read. Why? Because there is always a difference on a court can set aside an election for non-compliance with electoral laws, for example, or even for electoral offenses. What you need to prove in these two scenarios is different. And even the standard of proof is different. If, for example, we're talking about non-compliance with electoral laws, for example, that candidate, the winning candidate, maybe did comply with a specific provision of the law. I don't want to give an example right now. They will ask you, how did that affect? Was that substantial? For example, you're saying that the winning candidate, I will give this example, the ballot staffed for him at polling station X. And they determined that at polling station X, there are maybe 300 voters, but the winning margin is 10,000. Court will agree that it is true at that polling station, the ballot staffed. However, even if we got these 300 votes and get to you, the losing candidate, the petitioner, would you win? Now, if you do not appreciate the differences, that you can prove something and court agrees with you, but then says it could not affect the result in a substantial manner. Yet also, you can prove, for example, an electoral offense, an illegality. You say no, at such and such a place on such and such a day, the winning candidate bribed the voter with $1 US. That is about 3,000 shillings, Uganda shillings. If you prove that, that is enough to set aside an election, even if you have a vote difference of 100,000. Now, this helps you determine where do you put the emphasis. It helps you. What should I even take to court? Should I waste time alleging that the ballot staffed at polling station X, and then they will require me to bring the substantiality of if the substantial effect to prove the substantial effect of that non-compliance, or I go and prove that candidate X went and bribed the voter with $1 US. These things can help you if you read. And interestingly, the electoral laws may have been enacted by Parliament, but then it has been courts that have been defining the application and the extent to which those laws can apply. So, most importantly, you need to be well read, because the lawyer, a candidate will come to you and put to you very many facts which you think are morally wrong. The other day I was reading, I'm following the elections in Kenya, and I was watching some event at the coast where an elderly man told was alleging that if he had been the mother of, if he had met Honorable Ruto's mother, probably would have been the father of the vice president. That is annoying, that is irritating, and maybe you could argue morally wrong to talk about somebody's mother. But if it was said and uttered by a candidate, would that found a ground for petition? Would you go to court and say the man said if he had met my mother, he would have been my father? It would hurt you, but it cannot found a reason for you to go to court. So it is important that you read and read well and keep yourself abreast with the current developments in determining election petitions. Why is it so? Because the countries that fall under the East Africa Law Society are largely common law countries where we follow precedent. And a precedent in Kenya can be cited in Uganda, and it can be persuasive authority that that can be applied in court of law in Uganda and can determine an election petition. Finally, and most importantly, of course, it is important to consult. An election petition is always cumbersome and involving, given the fact that it involves bringing so many different pieces of evidence and it is determined in a very short time. It's important that you ask where you don't know. We are talking about how do you prepare and successfully prosecute an election petition. No lawyer is so knowledgeable to know the fine details of and the most recent developments in prosecuting election petitions. So it's important that where you're not sure, call on others, and then you can be able to prepare a good petition. You can be able to prepare good arguments and look for the best authorities that you can then put before court so that you can be able to successfully execute and win your petition. Thank you so much. I can now hear from the participants if there is any information that they may want to get from me.
Thank you very much, Mr. Galisonga. If there are any questions for any of the panelists, they can be written down in the question and answer area. We'll deal with them as we go along. And for the panelists, you have the choice as to whether you can answer directly to the questions that are going to be raised, or you can go live and actually answer them. So I'm Elizabeth Musikali. I'm also an advocate of the High Court of Kenya, and I'll be co-hosting this session together with Ms. Brenda Makoha. And I'll introduce the next panelist, who is Mr. Jebra Kambole, who is an advocate of the High Court of Tanzania and is the co-founder and head of litigation at the Law Guards Advocates, which is a multifaceted legal firm based in Dar es Salaam, Tanzania. He's also one of the few lawyers who participate in public education on law and human rights in the media. And as well, he's a member of the Tanganyika Law Society and the Committee of Constitutional Legal Affairs in particular. So Mr. Kambole is also a public figure and a human rights activist. He believes change starts with him, and it is his passion to see a society with legal and social justice. So Mr. Kambole, how has the advancement of technology impacted electoral laws and practices?
Thank you so much for such introduction. And what I can say is, good afternoon, everyone from East Africa. Here in Dar es Salaam, it's hot. So let me start by saying that to end where Julius was speaking about the election cases, I believe that the advancement of technology made a lot of changes. I'm sorry I'll be referring so much in Tanzania because that's where my practice is based. But you will be checking to your own context. The advancement of technology has impacted the electoral laws in several ways. Example, in Tanzania, we have the Electronic Transaction Act, which was introduced in 2015. And this act is governing the admissibility of electronic evidence. So even in the election cases, the time of hearing or conducting the cases, there will be admissibility of different evidence. So as a young lawyer or the lawyer who want to participate in the election petition, you have to prepare your electronic evidence to see how they are going to be admissible in your cases in court. As you can see, during election, you need to prepare the grounds for nullifying election. Some of them, they need some evidence. And now in most of the African countries, you have the admissibility of electronic evidence. So you just see in your own context, how is it possible to admit electronic evidence? Be it video, be it a text message, be it a WhatsApp message, be it an audio message. So if you want to prove corruption, you want to prove hate speech or misconduct, you need to collect electronic evidence. And now, from the beginning, example in Tanzania, the admissibility of electronic evidence as provided under Section 18 of the Electronic Transaction Act is very clear. So you need to prepare how do you keep your evidence from the way they are genuine before you tender them in court. So that's among of the issues. And you can visit the case of Emmanuel Masonga and the Edward Malongo. That was 2016 election petition, which was part of the southern part of Tanzania, which was in Njombe, where the court tried to discuss about the admissibility of electronic evidence, and this was during the campaign. The body parties, the court did not receive the said data message because of the way it was. There was no evidence on how the storage was how the video was recorded, how it was kept, and how it was tendered. That's why the court denied to admit it. So that means that you have to prepare from the beginning. How are you going to use the said electronic evidence in court, even election petition? Oh, there are other issues in other countries. For example, in Tanzania, in your constitution, it's very clear that you can't challenge the presidential election result. And now this technology did not affect anything as far as the presidential election cases is concerned. In your constitution, it's very clear that you can't go to court to challenge the presidential results, and that's might be surprise to some of the participants, but that's the position of the law. Though in 2018, I challenged myself in the African Court of Human People's Rights, and the African Court of Human People's Rights, that was in application number 18 of 2018. You can search in your Google, Jebla Kambole versus the United Republic of Tanzania, where the African court was very clear that our constitution is actually against the African Charter, but also some of the international treaties as far as the election petition are concerned. The other thing which I see as the changes in context in Tanzania, the coming of the technology, the issue of video conference. I hope that many of the Eastern countries allow the video conference cases. So now even in Tanzania, we have such thing, and you can even conduct the case. What you need is to prepare for it and know how are you going to handle it through video conference. The technology also affects some of the issues. In Tanzania, it's not allowed, but I see in Kenya, it's very common to see that the live streaming of the cases, people can see the proceedings, how it's going on, how you conduct it. That's very positive changes. Though in Tanzania, it's not. We don't have that laws or guideline on particular aspect of live streaming. But also, the other part which I want to talk about, the coming of technology has affected more also on the registration and voting process. Though most of the countries, example in Tanzania, we don't have the clear laws, example, maybe how do we protect our data and so on, but we register our voting process electronically, but we are still voting manually. And that's a challenge, it's a challenge. So we need to improve more in our laws to make sure that they align with this coming of new technology. And also the impact of technology has affected the transfer and counting of votes. How do you count your votes? How do you transfer votes? In Tanzania, we don't have such clear laws in the National Election Act, though in practice, it's happened that you send some of the information, example, some of the result in some part of Tanzania where election is conducted, then you transfer them to the other part. But there is no guiding principle to ensure the genuineness of how do you transfer the said votes and the counting process. So we need to improve more our laws to make sure that they're in line with what you are talking about. But what I can say is the most important part which is affected by coming of the new technology is the issue of admissibility of electronic evidence. Just see in your context, in your country, how is it possible to admit? Because most of the things are done during election. Some of them are conducted in a secret manner, but some of them in the public. But you need some evidence to prove or to testify before the court of law. So that's what I can say in brief. Thank you so much. So I'll be waiting some questions or some comments on that. Thank you.
Thank you so much, Mr. Kambole, for that presentation. Up next, we have Mr. Moses Kippage. He is an advocate of the High Court of Kenya. He is a partner at G&A Advocates LLP. He has a wealth of experience and knowledge in diverse fields of law, including constitutional law litigation, human rights enforcement, environmental law litigation. He has worked in key institutions such as the now defunct Electoral Commission of Kenya, the Office of the Attorney General, and the Independent Electoral and Boundaries Commission. He has participated in developing the law reform policy framework for the commission, which informed the amendments to the Election Act, and a host of other electoral law statutes. He conceptualized and drafted the elections regulations, amongst other regulations made under the Elections Act, to govern the conduct of elections in Kenya. Welcome, Mr. Kippage.
Thank you very much, and thanks for that introduction. I have a simple assignment this afternoon, and I hope I'm audible enough to take us through the effects of COVID on the electoral processes. And just by way of introduction, I have worked with the Electoral Commission of Kenya, the EMB, the elections management body in Kenya, and I should be in a position to just bring about the interplay between the law and the practice of elections vis-a-vis the COVID pandemic, which has affected the world. I will speak from the context of Kenya in particular, because I'm familiar with the practices in Kenya, and where necessary, I'll draw examples from the region. I will share the paper. I have done a short paper, which I'll share with the Secretariat, which can share with who can share with the participants. So COVID was a bit unprecedented in terms of how it affected the processes governing the elections. In particular, the first effect was, should countries run elections considering the fact that elections by its very nature is a very interactive process. It involves parties, voters, candidates interacting at various fora, at campaign fora. It involves polling officials. Like in Kenya, the polling officials would number in the region of around 300 to 400,000 individuals. So that the question becomes, is it even morally right to risk the lives of those many people for purposes of an election? So, so to that extent, I think the first reaction which happened is, notably in Kenya, was that immediately COVID was declared a pandemic. There were a series of postponements, not just in Kenya, but in many countries. And I including what one may say was a breach of the Constitution of Kenya, because by law in Kenya, by-elections ought to be conducted within certain timelines. One of the elections which was being awaited in February of 2020, when COVID was declared a pandemic, was a parliamentary by-election in the coastal region of Kenya, known as Msambweni. There was a constitutional timeline of 90 days within which that by-election ought to be conducted. But in view of the fact that nobody knew the effects of COVID and how it would affect personalities in the process, that election had to be postponed. So the first implication of COVID was delays. International IDEA has published a lengthy article which demonstrates the number of countries who have had to delay elections, and they number over 70 countries which have had to delay their local government elections. They have had to delay their national elections just because there was no particularity as to how COVID would affect them. So the biggest casualty with respect to COVID is participation by candidates, participation by voters, participation by election observers in the electoral process. And largely because the laws have been designed in such a way that a voter has to walk to a polling station, be issued with a ballot paper, probably walk to a polling booth, mark the ballot paper, and cast it in a ballot box, which at the close of poll, that ballot paper has to be extracted from the ballot box and counted. What it then means is that in that entire value chain, there is a lot of interaction between the polling officials and the voters and the agents of the various candidates. The consequence of which is that because of that interaction, then the polling process becomes a super spreader event. Now, so the first effect is campaigns. Campaigns in Africa, we know we do not conduct our campaigns in boardrooms, in conference halls. We go to the field, and like it happens in Kenya, it's competition about whose crowd is bigger than the other. You might have seen on social media about parties, candidates trying to demonstrate that our crowd was bigger than the other. But that would be a scare for health professionals because they're saying those are super spreader events. The consequence of which is that when government issues directives stopping such crowds, it then affects participation by the voters and the candidates. The other thing is voter participation in the process. At what point do voters engage with the polling officials? For instance, the EMB in Kenya, Iebc, is obligated in the Constitution of Kenya to educate voters. Short of using social media and other forms of electronic media, the Commission would ordinarily walk out there and engage with the people and advise them as to the mode of elections, the process of conducting elections, where to vote, when to verify your details in the register of voters. That again is affected by COVID. And because of the fact that people consider their health first, if an election is undertaken in the midst of COVID, you can be sure that participation will be low. A by-election was undertaken in a constituency known as Juja in Nairobi, and it attained the lowest turnout ever recorded in Kenya at 14%. So you can see the participation by voters in the electoral process. It's purely anecdotal. It cannot be concluded that it was because of COVID, but one would say that there's a causal link between the fact that COVID was happening and the turnout in that election. The voting process itself, people do not want to interact in that regard. So what are the opportunities? We all know that our justice system throughout the region in East Africa has always been one of you walk to court, you meet a judge, you argue your case, and leave the judge to render a determination. But because of COVID, that was also affected. And the reaction by the judiciaries across the region was to deploy the technology. Is it also an opportunity for our elections managers, our EMBs in the region, to also start thinking about electronic voting, thinking about voting which is less interactive, electoral processes which are less person-to-person contact in terms of campaigns, in terms of voting, in terms of counting, in terms of the tabulation of results, and in terms of relaying those results, aggregating the results and announcing a winner without necessarily having to put people together in one room, either for purposes of voting, put people in a stadium for purposes of campaigns, and such like activities. So I think there is an opportunity for discussions to be had within the region. It could be under the auspices of this great forum, the East African Law Society, for interventions which leads to adoption of online voting. The risks which we were always told about interference with technology by candidate. We've not seen that happen in the courts. And even if there was one or two incidents, there has been opportunity for growth. And my view would be that in COVID has presented an opportunity to invest in technology. In any event, in the long run, elections becomes cheaper. People do not have to travel far. It is easy to manage the register of voters. It is easy to manage election observation and monitoring of elections with technology. And perhaps I should mention this, one of the effects. We all remember the incident in Burundi when they were undertaking their presidential elections. And when observers from the region sought to go and observe elections, what did the government do? They said, well, you land, we have a 14-day quarantine period. And it made a mockery of the entire process. That should end my comments with respect to the effect of COVID pandemic on the electoral processes. Allow me to just comment also on the raging debate in Kenya about the Election Laws Amendment Act, which is currently pending before Parliament. My comments on that bill are threefold. That bill has been designed to achieve three things: to clarify terminologies which has been used in the Constitution and in the election laws, and notably the usage of the word nominations, which has now been clarified in that bill to mean the process by which a political party selects its candidates for purposes of an election. So what then the bill has done is to amend where that word has been used so that it excludes it from the process by which the Commission or the EMB registers candidates to participate in an election. Now, the second bit is now to distinguish that process of the political parties conducting their primaries or selecting their candidates from what the Commission does with those candidates when they are now appointed, which is to register them as candidates. And that's how the Constitution of Kenya, that's the language used by the Constitution of Kenya, registration of candidates as to participate in the main election. The second bit relates to, or the second objective of that bill is to align the Elections Act, the law governing the electoral processes in Kenya, with the amendments which were introduced to the Political Parties Act with respect to the manner in which the political parties undertake their business, whether it is recruiting members or nominating their candidates to participate in an election. Hitherto, those provisions were governed by our Section 31 of the Elections Act, and if you go through the bill, all those sections have been plucked and transplanted to the Political Parties Act. The third aspect of that bill relates to the most controversial aspect, which is results transmission. And I think there's been a bit of misinformation or mischaracterization of that information about that intent in the bill. We all remember the incident in 2017 when Parliament sought to amend the Elections Act midway through the elections. After the annulment of the presidential elections of 2017, Parliament amended some sections of the Act, and notably Section 39, which governs the results transmission pathway. Now, the Katiba Institute, an institute which describes itself as a champion of democracy, went to court and challenged those amendments. And Justice Chacha Mwita, a judge of the High Court in Kenya, annulled virtually all the amendments which were introduced by that law. The consequence of which was that, and he didn't clarify the effect of those amendments, the consequence of which is that the results pathway was a bit limping, as it were. It was not quite clear. And what Parliament is now seeking to do is to replace those provisions which were annulled by the court with new provisions. Now, one of the provisions which were annulled by Justice Chacha Mwita is what has been described as live transmission. It was annulled by Justice Chacha Mwita, and is sought to be replaced by another clause, which makes manual results to be the primary results for purposes of an election. There could be debate about the utility of the amendment or whether or not those amendments should be carried the way they are. But I think, in my view, it is important to replace the annulled provisions with something else. There has to be some results management pathway within the law. Otherwise, you leave the EMB with quite some discretion on how to deliver the results, which is far much worse than having a results pathway, which is set out in law. So that would be my comment with respect to that bill. It is important, and I think the comments which were made by Mr. Kambole from Dar es Salaam are quite apt. What should be the role of technology with respect to management of elections? I would imagine that while we may have a challenge using manual results, and that is the biggest concern for those who are saying this is another avenue for cooking results, as it were, cooking, quote unquote, we need to ask ourselves, how is the results management process undertaken in Kenya? The result is itself at the polling station is largely manual because it is generated by a presiding officer who then fills up a form. We call them the A series, either from 34A for presidential elections, 35A for National Assembly elections, all the way to governor elections, which is, I think, 39A. It's a form. The question is, how is that result captured in that form to be transmitted to the either constituency or county or national tallying center for purposes of the election? Now, my thinking, and perhaps in due course, the thinking should move to how do you derive a result which is electronic from the word go, which excludes the presiding officer. Because the same presiding officer, and I can give the scenario of Kenya, was so distrusted with managing the register of voters to the point that billions of shillings were invested in acquiring technology to manage the register of voters. And as it is now, the register of voters is wholly electronic, so that the voter walks into the station and is identified through their fingerprints and not, through a printed register. Now, the consequence of which is that you stop the malpractice of the presiding officer allowing dead voters to vote or impersonating those people who may not have turned up at the polling station to vote. But the same presiding officer is the one who is being allowed to fill up the form. The same presiding officer we distrusted with the register and deploy technology is the same presiding officer whom we are trusting to generate for you the result form. That is before you start discussing transmission. So I think, in my view, the discussion is a bit misplaced. It should be about the investment and the thinking around how to make the result electronic before you start thinking about how to transmit it, because those are different processes in the value chain. And as we were told by learned counsel from Mr. Kalisonga from Uganda, it is a process which moves like a river and it has no reverse gear. So if the result was polluted at the point of filling in the form, how do you save that? By transmitting it electronically. Thank you very much. I am available to answer your questions. Thank you.
Thank you very much, Mr. Kipkoge. That was very insightful, especially on the proposed amendments to the Elections Act, as well as the impact of the pandemic on electoral processes. So I'm sure there are very many questions with regards to especially the amendment, the proposed amendments, but you can keep typing them out and we will deal with them during the plenary session. So the next speaker who I'll introduce is Mr. Alfred Locke, who is a distinguished lawyer and managing partner at Okello Oriem and Company Advocates in Uganda. He's also an experienced litigator with a particularly strong focus on electoral litigation, and he has represented the Electoral Commission of Uganda in numerous presidential petitions since 2011. So Mr. Locke, do you think there is need to harmonize precedents of election petitions in the East African community?
Hello, can you hear me? Hello?
Yes, we can hear you.
Yes, we can.
All right. So the concept note gave me 10 minutes to answer that question. I'll try to do it in 9. Yes, of course, I do believe that there's a need to reconcile. There are about three main reasons. The first one is, of course, you have the principle of precedent itself, stare decisis, right? If you have conflicting precedents, you get into chaos in the lower courts, especially. I'll just give you an example. The 2006 presidential election petition in Uganda was decided, among others, on the basis that if a voter is able to demonstrate using what used to be called their voter's card or the voter registration slip, which is the equivalent of the current voter locator slip, then they are proved that they're a registered voter. So the Supreme Court held that about 230,000 Ugandans were disenfranchised because even though they had these documents, they were removed from the voters register. 2011, which is anywhere from 5-6 years later, the Court of Appeal sort of upheld that position. If you find the case of Ikuluku Faizo against EC and others. But 2016, if you look at Kinyera Simon versus EC, the Court of Appeal says the only way to prove that you're a registered voter for purposes of polling is through the voters register. Now, imagine the chaos that brings in 2021. Now you have decisions based following Kinyera, and you have decisions. So that's one area. The other affidavits commissioned by uncertified commissioner for oaths. This was among the hottest debates in the 2021 litigation coming out of the elections. Now you have a decision of the Court of Appeal, one decided before the Constitution in '95, returning officer of Uganda. No, slightly after the Constitution. Then you have another one decided in 2016. This is what's the guy's name? Kinyamatama. Now, both of them, the earlier one was decided before an amendment of 2002 in the Advocates Act, which says that you can re-administer an affidavit commissioned by a certified commissioner. That was the one of returning officer Uganda. But the one of Kinyamatama was decided after the amendment. And what the court said, Court of Appeal, both of them Court of Appeal, was that an affidavit with that problem is invalid, but you can submit the matter for re-administration of the oath instead of dismissing it. That was 2016. Now, come to 2021, you have judgments saying such an affidavit goes for re-administering the oath, but you also have judgments saying that a petition supported by an affidavit like that is incompetent. Those falling in the second category were all dismissed. Those falling in the first category were all hard on merit. The result is you have litigants who cannot understand why the other argument was not applied to their cases. So it is important to have harmony in precedent. Just one last area before I conclude in my 10 minutes is this. The 2001 presidential petition was decided mostly on borrowed precedent, if you like. We did not have a lot of precedent locally. So we borrowed a lot from Nigeria, Kenya, TZ, and the Commonwealth. Problem there is the hierarchy. We were quoting cases from the equivalent of a G1 or a chief magistrate to the Supreme Court of Uganda. So there are issues of binding effect, persuasion effect. We still have that problem. The East African Court of Appeal used to be equivalent to perhaps the Supreme Court in the early days. There are some arguments now that its decisions are not binding on the Supreme Court. So in the East African referencing, but you have to keep in mind the hierarchy and whether you are trying to persuade or you are submitting on a binding precedent. So that's the bad news. The bad news is that there will be chaos in the courts and in law school as well if you have this harmony in precedent. The good news is that at least in the case of Uganda, the appeals are coming up for hearing starting Monday. So we are processing precedents for both arguments, for both sides of the argument, with the hope that both sides can be placed before the Court of Appeal, which happens to be the final appellate court in Uganda. For election matters, and hopefully tell us which of their previous no longer be followed. What's a constant, in my personal view, as a problem that still remains is when we used to have second appeals to the Supreme Court. So there was an opportunity to review some of those conflicting precedents. We don't have that now. I'm hoping that after the litigation in 2022, if you like, the business case for review of this position perhaps could be made. My personal view is that there should be second appeals so that our precedents are tested, and when they go up to the Supreme Court, you know that the lawyers and judges have applied their mind fully. Having said that, we are hoping to maximize next week and the next 1 month to try and create harmony in precedent. I think my 10 minutes are over. So that's really the presentation that I put together. Thank you very much.
Thank you so much, Mr. Alfred. Up next, we have Mr. Steve Asen Nimuboma. Steve Asen Nimuboma is a lawyer and a member of the Burundian Bar Association, and he currently practices in the firm of Gilbert and Partners in Bujumbura. He is going to answer the question on the sufficiency of the election laws in East Africa. Welcome, Mr. Steve.
Thank you for the floor. Do you hear me well?
Yes, we can.
Okay. First, good afternoon to everyone and Happy New Year. On the question of the sufficiency of electoral laws in East Africa, the answer is no. Because I think first, there are numerous laws that govern election in East Africa. I think they should be put together to do a unique instrument. Second, I think as the laws are often changed or amended, I don't think it's a good thing because it may be seen as a way of excluding some candidates. So I think we should have a consistent electoral laws within East Africa to bring trust to electoral processes in those countries. To go to the content now, I think I'm going to focus on my country, Burundi, since I practice there. Our electoral laws have many lacks. They are not sufficient. For example, on the voting capacity, our electoral law provides that people in custody cannot vote. They are deprived of the voting rights. But the Constitution says that every Burundian who has the age to vote has that voting rights. And people in custody cannot vote, even though they are not condemned yet. They are not sentenced to, they are not yet sentenced, and there's no loss of that right. Where there are candidates who are already convinced in the first instance, in the lower court, but as they appeal the decision, they still have that right to be candidate. So I think that's a lack. That's the first. The second is our electoral law don't have provision pertaining to the funding of campaigns. That makes that people who are on power, the ruling party, have more financial means than others. And I've seen that in East Africa, only Tanzania and Kenya have an act that governs the funding of elections. But it's not sufficient, as, for example, in Tanzania, the political parties are required to disclose the names of their donators, those who give their donors. But I think they should limit the donations because it makes a fair competition. Another matter is access to public media. In many laws, it is provided, but the problem is the implementation and enforceability of that. Because you find provisions say that candidates do have equal access to government media or public media, but there are no formal ways of compelling those media to comply with those provisions. So I think it's a big problem that legislators in the East African countries can try to legislators can try to correct. They can try to correct those lacks, and so that laws be trusted by everyone. Let me come back to what I was saying about the amendments of laws. I'll give you an example for the Burundian case. For the 2020 elections, it was enacted a new law, which was enacted in 2019. And that law said that an independent candidate has to be out of a party since at least 2 years. And that law was enacted in 2019. So you can hear that it wasn't possible. It was, people thought it was to exclude some candidates from the opposition. Second, it was provided in that law that for a candidate to presidential election, he has to be Burundian, an original Burundian. So, and have that only citizenship. It was in the context where we were, it was like exclude people with double nationalities so that, because they thought they are the ones who caused troubles, according to what happened in 2015. So I think all that can be corrected, and that's the end of my presentation. Thank you, Brenda.
Thank you very much, Mr. Nimubona, for that presentation. So we'll go on to our next speaker for today, who is Mr. Rich Maluel. And Mr. Rich is the managing partner of Ancestral Advocates and is the chairperson of the Coalition of Public Interest Litigants in South Sudan. He's also the executive director of the Screen of Rights, a human rights national non-governmental organization registered in South Sudan. He also serves as the Deputy Secretary of Information at the South Sudan Bar Association and is a fellow at the US Institute of Peace. And then lastly, he's also a public law and media consultant. So Mr. Maluel will talk about whether, in his opinion, does he believe that the courts of law can make independent and fair decisions in election-related matters, free from the influence of the winning parties?
Thank you so much. I do appreciate the fact that I'm participating in this high-level discussion, and I have to thank the East Africa Law Society for organizing this. It is indeed depending on the country that one is coming from, with respect to whether we have courts of law that can make independent and fair decisions in the, in the elections-related matters. Literally, we have seen recently in Kenya, there is a good precedent where a presidential outcome was challenged successfully. But in other countries like South Sudan, we still have a difficulty where the judiciary is actually an ally of the executive. And that makes it so hard to say that there is a system of judiciary or courts of law that can be able to make independent and fair decisions. However, it doesn't rule out that there are still few judges who are very much respecting principles that are allied with their practice, like, for example, fair trial and all of those. there are people within the judicial system that can still respect that. But however, in South Sudan, there is no single precedent that has been recorded. The elections that we had was still when we were still not yet a country in 2010, April 2010. But disputes were not handled in the in a legal way after the elections. Perhaps candidates who felt that they were, the votes were taken away from them, whether forcefully or in an unfair manner. They sought a rebellious way rather than taking a legal action. And so we cannot be able to verify. But in relation to some other politically motivated cases that have been handled at the court here in South Sudan, we have also seen to some level that the judges would rather be forced by certain forces within the executive to decide to their side rather than decide on what the law says. But also we have seen at some level that a court of law to some level has also been fair. For example, in the case of former detainees, you would see that the court would be full with national security officers, which is not in any way a delivery of a fair trial, because when you see national security officers, the message is different to the judge. It's like, if you decide the other way, and then we're going to get you anyway. But then the verdict was still acquittal for the former detainees, and which was a high profile case. Literally, the way judges are being appointed in South Sudan makes it so difficult for any judge not to be allied to the executive. First of all, even if there is a judicial commission, that judicial commission does not do its work when the judges are being recruited. And the Chief Justice is single-handedly being appointed by the president. And one thing that I can remind myself, years back in 2017, the president issued a decree firing judges without any due process of the law. And in fact, the president does not have a legal capacity to be able to act to that effect, unless if the judge has been found maybe guilty of dishonesty or not being able to deliver his or her duties, and then the Judicial Commission will form a committee to investigate him or her, and then after that, the report from that committee will be used to be able to fire a judge. But here, seemingly, the president has absolute powers to be able to overturn every judicial systematic way of doing things, and that makes the judges to fear even for their own seats. And the public does not enjoy scrutinizing the work of judges, simply because, first of all, the work of judges is not published. And recently, a law report has been launched, but then that was the first law report on South Sudan. But as of now, it's no more. And that makes it so difficult for people to even know what the judges are doing. And seemingly, there was a case that involved political parties. And that case was whether the president had power to be able to make an addition to the number of states, or to change the number of states to less or more. When the order of the president came out increasing the number of states, the Chief Justice himself written in a newspaper congratulating this issue was challenged political parties and was headed by Dr. Lamakol, and one of the advocates was the current Deputy Minister of Finance, Agok Makur. He asked the the Supreme Court to be able to excuse the Chief Justice, since Chief Justice is congratulating the President on the same matter. When the Deputy Chief Justice agreed that this is a rule against bias and the Chief Justice should not be part of the panel, just that same evening, the Deputy Chief Justice was removed from his position and Chief Justice continued to be on the panel. So this, in simple terms, can be able to tell us whether there could be a free and independent or fair decision that can be made by courts of law in the Republic of South Sudan in relation to a winning party, for example, the ruling party, whether they rig the elections or they win it fairly and it is challenged, whether that can be fair. So I would still say that it wouldn't be so independent as we think. We have not conducted any elections yet in South Sudan since we became an independent country. We were supposed to have elections in 2015, but then in party primaries in 2013, that caused the war because the SPLM could not actually allow itself to have a free process of electing a flag bearer in the elections. And that what brought the country to the first civil war. And we can't rule that out yet, but still we are hopeful. The elections are being under the mandate of the National Elections Commission, which is given the mandate by the National Elections Act of 2012, where parties will be able to register their preferred candidates after having their own primaries. But then also there is a kind of appellate division within the of which if a party delegate is rejected or flag bearer is rejected, they can be able to make an appeal as well. And also courts of law are provided for, though we don't actually start with High Court, we go straight away to the Supreme Court in relation to elections issues, unless if those electoral disputes concern maybe the state parliament or else maybe governorship, and then it will have to be at the court of appeal. And so the question remains that in some countries in East Africa, we can say that some level courts can make independent and fair decisions, but in some countries as well, it is still a tough question to answer. I will have to end here in case there are questions to answer.
Thank you so much. Thank you so much, Mr. Maluel. Our last speaker is Mr. David Rugaza, who is an advocate of the High Court of Rwanda and is a partner at Rugaza Law Firm. Mr. David, you're welcome.
Thank you very much. I would like to start with my presentation, which is going to have only 10 minutes. It's an overview of election laws and the procedures in Rwanda and East Africa in general. It's not easy, guys, that we may talk about all laws and the procedures governing elections in all 6 member states. But at least we shall try to look together on what should be the laws and how those laws actually should be applied and what could be. Sorry, are you hearing me? Can you hear me, please?
Yes, we can hear you, Mr. Rugaza.
Thank you. Okay. So then, but this depends on the states. Normally, election laws determine the procedure to be adopted for the conduct of elections. What could be the procedure to be used? that we can get a procedure to be used in elections. And that is the rationale of election laws. And in most of the states, we used to say, where can we look? And where can we go in order to find those procedures? Mostly, we have first to refer into the constitution of any member state. Because the constitution, it acknowledges the way a state must be governed. And based on the constitution, we can actually try to see how election laws are provided and what could be the guidelines. Of course, it can't have everything, as it depends to the type of constitution which is there, but at least they have to see, or it has to put some key technical methods that has to be adopted. For example, let me start by Rwandan Constitution. When we look at Article 2 of the Constitution of the Republic of Rwanda of 2003, revised in 2015, the first point talked about suffrage is universal and equal for all Rwandans. The universality of suffrage, it doesn't mean that everyone, as a human being you are, you can come in Rwanda and start to vote. No. Still, this universality, which the Constitution provides here, it might have another restriction measures. And these restriction measures should be provided by the Constitution, or the Constitution should provide where another law should come from in order to regulate this. But at least it must come from the Constitution itself. Maybe when we look at the point 2 of that article, it talks about all Rwandans, born men and women, fulfill the requirements provided for by the law, have the right to vote and to be elected. You can now start to see that the universal suffrage here, which is the first point we have been talking about, it is starting to bring some restriction measures. But still, they add another small thing, which is much important. They say that suffrage should be either direct or indirect. A direct means you elect direct your leader, or indirect, you can elect someone who represents you for another election. But this should be secret. Sorry. Then they add something saying that unless this constitution or any other law provide otherwise, down they add that an organic law governing election determine condition and the modality for the conduct of elections. Immediately the constitution says that at least there are some key elements which has to come in the constitution. And based on those key elements, which are in the constitution, of course, which are not easy to be amended, we should also have another law which should regulate the conduct of elections. But still, that one are also provided by the constitution itself. Let's look at the example of the Constitution of Uganda. I think it's Article 59.1, which says that every citizen of Uganda of 18 years of age or above has the right to vote. In this context, it means that if you are not a Ugandan citizen, for them, they have started with restriction measures. If you are not a Ugandan citizen, you can't participate in the elections. Again, regardless of whether you are a citizen of Uganda or not, you should at least have a minimum age required by the law, and that law is the constitution. Actually, the law itself is talking about the procedure and who to vote and the where to vote. When you look at the point 3 of the present constitution of Uganda, it said that the state shall take all necessary steps to ensure that all citizens qualified to vote, they register and exercise their right to vote. At least this is something very good and very important. Regardless of universality, regardless of whether all Ugandan has to vote, regardless of the minimum age, at least it also brings another point of procedure to which the state must contribute so that at least whoever who fulfills the requirement should register. And this is the facilitation of the state, which the state has to do to the citizen. Again, point 4 also, it talks about the parliament shall make laws to provide for the facilitation of citizens with disabilities to register and vote. You see now the constitution is actually referring to another point, to another law, which has to be enacted by the parliament in order to regulate the facilitations. Those are also another procedure which has to be adopted. So when you look at the example of the Kenya Constitution, Kenya Constitution also doesn't have any difference compared to Rwanda and Uganda. You will also find that it also have the same, actually the same spirit with the previous constitution, which I've already talked about. Actually, why did we focus on such kind of constitution? It's because, you know, the constitution is normally divided into 2 parts. The part 1, it talks about the theory of state, where there are some political powers, the power, the supremacy of the constitution. The second one comes with electoral system, which actually try to justify and to show how the elections are supposed to be conducted. That's where we get election laws. And when you look at the point, example 3, point 38, which talks about the political rights in the Kenyan Constitution, you will find that every adult citizen has the right without unreasonable restrictions. Actually, when you talk about unreasonable restrictions, how should we know that the restrictions are reasonable or are unreasonable? That's where most of the time the problem comes. Where some people may say that, no. There's a restriction which has been put in place. They are not reasonable at all. They are not provided by the law at all. They are not supposed to be implemented at all. This is the violation of the law. Otherwise, the elections are not fair. Why? It's because as long as the law has not been implemented well, immediately people will start to say, and that is true, that the election has not been fair and free. So once it talks about this, it says that every adult citizen has the right, without any unreasonable restriction, to register as a voter, which is good, and to vote by secret ballot in any election or referendum. Actually, this is also another example, a good example, which shows about election. I say that some laws should be provided by the Constitution, while another law should be directed to be enacted by the parliament in order to supplement the Constitution. But at least there must be some technical methods provided by the Constitution, which cannot be easily to be amended in order to regulate elections. Let's look at the example 4, the Constitution of the United Republic of Tanzania, which is in chapter 1, part 1, which talks about the United Republic and the people. Point 5, number 5. Subpoint 1, it talks about every citizen of the United Republic who has attained the age of 18 years is entitled to vote. This is for every citizen. And those citizens should be a Tanzanian citizen. No citizen apart from Tanzanian citizen can be allowed to participate in election. But again, they have also bring some restriction measures. You can't vote if you are being a citizen of another state, being mental infant, being convicted for a certain specific crime offenses. For example, they might say, this is an example that I'm giving, that if someone is convicted for 6 years and more, cannot be or cannot participate to the election. But still also, the Constitution also has said that the parliament may enact a law imposing condition restricting a citizen from exercising the right to vote. Yes, it is universal, but the universality of the Constitution, the universality of elections, it doesn't mean that it comes to whoever. No, it must be regulated. Another example, it comes to I've tried actually to look at the constitution of each state. Let's look at the Burundian constitution. Title 4 of election. Article 87. It talks about the right to vote is guaranteed. In Burundi, everyone has the right to vote. And elections are free, that's Article 88, transparent, and the electoral code determine practical methods for election. They might have a code which should determine how the practice should be implemented. But guys, I want also to talk about one thing. These are laws which are provided by the state. Of course, I will also talk another one. But there is also another element of constitutionalism. The implementation of the constitution, implementation of the laws which are provided by the constitution and which is guiding the elections. How are we implementing it? Let's take an example of the South Sudanese constitution, Part 2, Bill of Rights. Point 26, it talks about right to participation. This one says that every citizen shall have the right to take part in any level of the government directly or through freely chosen. Yes, you can elect yourself or you can choose someone to represent you, but everyone has that right. And he has also the right to be elected in accordance with the constitution and the law. In accordance with the present constitution and the law. It means that there's another law which has been enacted in order to supplement the constitution, so that it should show how the election has to be conducted. What could be the procedure to be used in the election? Of course, as we are signatories, all East African member states, they are signatories to many international instruments, to which actually I've tried to take on to read. I've not gone far because of the time. I've tried to look at the International Covenant on Civil and Political Rights, ICCPR, in its Article 25. It's also provided that. And every instrument, actually even in this one, it talks about unreasonable restrictions in Article 25. You can see that those restrictions are provided by them. Unreasonable one, those are restrictions which are not provided by them, which means that the restrictions should be there. The restrictions are provided by the law. If they are not there, then that means any state or any given, the Electoral Commission, they are dictating citizens. They are not respecting the law. When also look at another example, it's Article 21 of UDHR, Universal Declaration of Human Rights. It also says that everyone has the right to take part of his country, direct or through freely chosen representative. But again, in the context of promoting, actually, because we can't talk about election without bringing any idea of democracy, and this one should come through the law. East African member states has been challenged with the most important democratic issue of free and fair elections. I'm not going, guys, to talk about or to mention any state. No, I'm sure you are much the senior expert than me, but in your respective countries. But we can also look at the way election laws are implemented. It makes it possible to decide whether elections are free and fair. The reason is the awareness behind election laws. It's only focused on two things. One, it is who votes. Two, when that person can vote. As long as who votes and when that person can vote are not respected, obviously, regardless of whether you can have a law which are decorated in whatever language you may wish, grammatical, I don't know whether there is a grammatical errors or whatever, but still it will bring some issues. The awareness of those laws should at least be on how are we going to respect, how the law are respected. But still the stability of the law is the key of electoral process. Electoral process should be at least stable. Let's look at the example where the procedures are changed every time. And how, to what extent can we protect this? Remember that laws which are changed every time, sometimes you might even find that people are not confident in it. People may start to think that these laws are just made there in order to mask people, to mask a citizen, because they are changing every time. And sometimes they make it to be confused people. They put the procedure which is very hard. Assume the example where you might find that the law says that everybody should become in election where he has a suit. That's an example, by the way. It's not provided anywhere, but an example where you might confuse some voters. This really becomes a very, very critical. That's why, to make it clear, it's not good or better that those technical key of the laws of election or of the method of election should be provided by the regulations. At least it must be provided by the Constitution or any other enacted law or the act, which is not easy actually to be amended. That is what would actually help the stability and the fair election. Otherwise, everyone, sometimes you might find that even any citizen, actually the Electoral Commission may come anytime they want, they change everything, they bring what they want. Maybe they want to favor someone or they may not want to favor someone, but at least this has to be in harmony. It has to, it shouldn't be easy to be amended. But of course, you can't bring all the key points, all the points which are provided by electoral law in order to be provided by the Constitution. There are some technical that should come, the technical methods. For example, universal suffrage in the language of the Constitution. It talks about everyone has the right to vote, has the right for election. So if everyone has the right for election, at least there might be another laws to regulate it. Which it has to talk about the age, nationality, residence, and the clause suspending political rights. I remember when I was just reading this, I remember when I was still at the secondary schools. One day we have been told to elect a class representative. Of course, we wanted someone who might help us, who might give us a favor, so that whoever who may make any mistake, he has to be protected. And the person that we have been focusing in, it was that one who has been committing a mistake every time. We say that at least if that person is elected, he will help us. He will not take us to the headmistress, as long as he's the one who started to commit all those problems and mistakes, making noise in the class. So that's why we may not say that the universal suffrage as the way it is without putting restriction measures, then we think that we have made something which is very correct. No, we need also to think about some restriction measures. Another example, it has to come with equal suffrage. Equal suffrage has 3 points. There is equal voting rights, equal voting powers, and the equality of opportunity. People should be given equal opportunity, the freedom of voters to express their wishes, and combating electoral rights. This is much needed. And also, we also have to look about the procedural guarantees, which at least should be enacted, like organization of election by an impartial body, which is not from one political party only, and yet the constituencies is involving a number of political parties. Observation of elections, the observers should be allowed, national, international, East Africa, all those ones. Also, they might have a kind of security, so that as long as those people who are there, they got a problem, they might have where to get any support. And we have also to remember that in most of the time, as long as the implementation of the laws are not respected, people brings problems. You will find where they say that some place, it's not in East Africa, but there are some places where you may even heard that there are 2 presidents, 3 presidents, 4 presidents, where people may say that, oh, I'm the winner, or another one, I'm the winner, I was the one who was elected. Why? Yes, sometimes the people may proclaim themselves saying that I'm the winner, and yet really is not the winner. Why? Because he has not accepted that the election has been fair and freely, and yet it was there. But to another extent also, it's also better that the implementation of the law, which has been enacted, either by the parliament or through the constitution, it has to be respected. And of course, they are not exhaustive. I can't say that I'm going to talk of each laws in each country, but at least the key or technical methods should actually be provided there in order that the constitution can be, the election can be conducted in good manner. Thank you very much.
Thank you, Mr. Rugaza, for that good discussion on electoral laws and procedure in Rwanda and in East Africa at large. That presentation concludes our first part, and we're going to get into the plenary session where I'll ask all the attendees, if you have any questions, you can raise your hand or you can type it out in the question and answer area. So I've identified a few questions in the comment section, in the chat section. And the first is directed to Mr. Kippage, where Samuel Juguna asks, can the Iebc introduce electoral or electronic voting in 2027? So I believe that is in the next election season, not this current one. So I'll ask Mr. Kippage to address that.
Thank you very much for that question. Really, in terms of the electoral process, it should be possible to introduce electronic voting. The challenge which has been experienced by countries which have deployed technology for purposes of voting rather than identification of voters and transmission of results, the experience from those countries has been phenomenal, really. I mean, India is able to manage 900 million voters. And the only way they're able to do that is because they have deployed the so-called DRE, direct recording electronic machines, which enables use of technology for identification of voters, issuance of ballots, and voting. And then ultimately they extract the chip and aggregate the results using a different device. And they did that to avoid hacking of the system. So they are able to deploy electronic, but it is not interconnected, so that the system is not hacked. So technically it's possible. The question is whether or not we are willing to invest the time, the energy, the thinking around it, the design, and then engaging stakeholders, being the voters and the policymakers, parliamentarians, and the like. Iebc should be able to deploy. Really, because what has happened in terms of the amendments which were introduced to the Elections Act in Section 44. I think they introduced in 2016 following the amendments proposed by the Criterion Committee, was that there shall be an electronic electoral system which governs identification of voters, registration of voters, and results transmission. So from a legal framework, it is really a question of just amending that section and adding and voting, so that then the Commission can go out of its way to procure, to develop the system which would enable that. And there are various systems across the world which that can be done. I think the challenge is the Estonia situation, where voting is not just electronic, it's also online. You can sit in your house and vote. That would be a radical shift, because that's perhaps the only country which has done online voting for such a massive en masse, as it were, for a national election. I mean, we do an online voting for small elections, but a national election, I think it's only one country in the world which has used online voting. So it should be possible. The question is how that may be done. I have seen another question on the chat. Perhaps Elizabeth, if you permit me to also answer that, which has been directed at me, which relates to the
yes,
question.
you can go on.
Okay, thank you. Which is whether how can we stop this hyperculture of amending our electoral laws every other season? I agree, Peter, that it is really it's a negative culture. It's not a good culture. But having interacted with the Elections Act and the electoral laws basically over time, my view is that we had a false start when it comes to our electoral laws. The laws which came from CIC after the adoption of our new constitution were not up to scratch. They were not adequate. They were not well researched. They were not well thought out. They do not they do not meet the expectations of the constitution. I'll give you a few examples. The Elections Act, which is the major law governing elections in Kenya, together with the Election Campaign Financing Law, the Political Parties Act, the Election Offences Act, and the other statutes. The Elections Act has been annulled over 16 times by our courts. It has been amended by Parliament 14 times. And in fact, after its enactment, it was amended 4 times within the first year of its enactment. So that tells you that it was not a well thought out statute, and that's why you still find a lack of synchronization. Like for instance, the word nominations as used in the Elections Act was used in a different sense and context from its usage in the Constitution. It's used in the Constitution to connote party primaries. But then when it's used in the Elections Act, it's used to connote the process by which the Commission registers candidates to participate in the elections. The other example is recall procedures. They are woefully inadequate. Procedures such as the referendum procedures, for instance. It was in court the other day, and the court picked out the fact that it doesn't set out, it doesn't amplify or provide sufficient support to Articles 255, 256, and 257 of the Constitution. The dispute resolution procedures, they are inadequate. The process of registering voters, and that's why every other time, even basic questions about who qualifies to be registered as a voter. Which documents do you use to register as a voter? One of the amendments which is being introduced in the Election Laws Amendment Act is to introduce the word valid in the usage of a passport. If you use a passport to register as a voter, then the act as it is now merely says passport, but we know in practice passports do expire. So the suggestion now in the law is to introduce the word valid so that the passport remains valid. If you use a passport, then you must ensure that it's always a valid passport. Things like those. One of the other amendments which is sought to be introduced is residency. that you must have some nexus, some connection to the area where you want to vote as a voter. Are you working there? Are you a resident there? Do you stay there? Do you own property? Why do you want to register in a particular ward, a constituency, a county? So all those are things which perhaps should have been thought at the time when the law was enacted in 2011. But as it is now, practicalities are emerging, and you notice that probably how do you stem people being moved? If I wanted to buy, for instance, in my county, in my constituency, I would probably collect all my relatives who are resident in the neighboring constituencies and take them to the constituency I want to buy in. That's why the law is being amended now to say, no, show some nexus with that constituency. So, and it becomes unjust when those amendments are introduced few months to elections, because the whole intention is then missed, because ideally you should amend electoral laws when the election is not near, so that there can be an objective discussion around it. Like that question of residency, it might be a good move, but when you amend it close to an election, it becomes a bit, some of the parties will not be happy with it. They would look at it as though they are being targeted. And that is, that then brings up the debate, like the debates we have in Kenya. But some of those amendments could be quite noble. It could be an amendment which, if looked at when there is no election in the offing, everyone would agree with it readily. So yeah, that is my answer to you, Peter. And thank you for your question.
Thank you very much, Mr. Kippage. For the attendees, you can keep on asking your questions or typing them out in the question and answer area. And feel free to raise your hand as well if you want to ask the question directly to the panelists. The next question is again from Peter Njoroge. And this question can be answered by any of the presenters or panelists. Does any of the presenters believe it is a good idea to have a regional election body which is financed by the regional body, that's the East African Community? And the basis of this is that it would conduct elections based on the electoral laws of each member state and the EAC treaty or protocols on elections. Peter believes that it would allow easier marshalling of resources, thus reducing the cost for an individual state. What do you think about that? Anyone can answer.
For me, I think it's a good idea, since the East African Community is aiming at political federation. So it will be another thing to implement an electoral body for all the countries of East African Community. I think it will be more independent and more fair. Thank you.
Thank you, Mr. Nimubona.
Can I add something?
Yes.
John?
Yes.
For me, I may say that it's good to some extent. To another extent, it might even remain the way it is. The issue is not to have a common laws. To me, I think that what we need, it is the implementation of the existing laws, which any given state might have, for the sake of conducting good and fair elections. That's why having it or not having it, to me, it doesn't matter. But of course, it might be better as long as we're in East African member state to have any common law, which might regulate everyone, which is good because you have even observers from across the countries, I mean, from East African General Assembly, but still, what is much necessary, it is to respect first what we have chosen and what we have agreed at any given state that should conduct the election. Thank you.
Right, Mr. Galisonga, do you have any views on this before we go ahead?
Of course, thank you so much. I'm sorry I've now had to leave office because I have an appointment. But what I can say is that not even the EU, which is a more developed organization of countries, has a universal electoral commission that they're organized, they have the financial resources, and I think the people in leadership have the will to lead well. How about in East Africa, where I think only in Kenya, a vice president can answer back a president, a sitting president in a campaign, or a minister can resign to go and join a candidate campaigning ostensibly against the interests of the president. It cannot happen. We can wish for it, but as lawyers, we don't legislate or even practice the law in the vacuum. We have to appreciate the realities of the situation, that we are in places where there is a lot of selfishness on the part of leadership, that allowing a body that can have an independent opinion is which can include nullifying an election, or even declaring a candidate who has one other than that one that a leader in power wants, is really wishful thinking, to say the least. So let's not speculate, given that the law does not operate in the vacuum. That's what I can say.
Elizabeth, probably I should weigh in also a little.
Yes,
I think as East Africa, it may be a bit ambitious to start to imagine or to start thinking of a regional EMB at the moment. But I think what we could think about in its place is a protocol under the auspices of the EAC for purposes of standardizing the common features of a free and fair election, so that when we ask ourselves what is a free and fair election, or what is an election which has been conducted by an impartial body, we have common standards across the region. So a protocol or a charter on human rights and democracy, or something like that, with observation from member states across the region, including the East African Law Society, with comments and stuff like that. That way, we should be in a position to enhance our democracy as a region. That's my view.
Thank you very much, Mr. Kippage and Mr. Galisonga as well. We'll go on to the next question, which is to David Rugaza from Christie, who asks, by saying that we should review limitations of the election laws, should we also include the level of education of the voters?
To me, I may say no. Even this limitation, what we have to look about is the restriction measures. And the restriction measures is much necessary. For example, even what have been given before, in the language of the Constitution, if we talk about it, universal suffrage, it means a lot. It may even lead us to every human being has a right to vote. But do we mean by that whoever who is present in that country has a right to vote? But again, when we talk about these laws, let me start with the limitation of the laws. We need to know what is the spirit of the policymaker, or what was the spirit of the policymaker in order to enact that law. Just, it is very simple. How shall we vote? And who shall vote? If we are able to do that, is it really necessary to change vocabulary every time? before thinking on how to change, we need to know first, what is it going to help us? And also those laws should be very easier for the voters to understand. Basic understanding, it doesn't require any education. Yes, it is true that people should be informed. We have to tell them that there is an election which is going to take place. Everybody should participate. These are measures which are there that everyone has to respect. You have to report on time. You have to come with electoral, you have to come with your card. You have to show your identity, things like that. But once we put much measures which are really very confusing people, and that's what I was just been focusing. It is, the answer is no. But at least we have to make awareness of the activities which is going to be conducted. Thank you.
Thank you very much. The last question is from Jambia, who asks, if we do not have a judiciary, if we do not have judiciary which can make an independent and fair decision on electoral matters, do you think the law itself can lead us to a fair election? I guess that question is open.
Yes,
yeah.
let me talk more a bit about it. Law itself cannot help anything as long as it is not implemented. It needs to have regulator. It might have someone to use it. So that's what actually I was been talking about. The reality on the ground. It's like having a constitution without constitutionalism. We have the law which is there, which are good, which are well designed, but to which we are not respected, which we are not implementing. We are not implementing it. And what could be the basis of it? What is the need of it? I think what is much necessary, I agree with him 100%. We might have at least the effective measures to make an appeal. Someone who has not been satisfied with the election should make an appeal. And where can he go? That should have been provided by the law itself. That we have to go this, to do this. But without that one, I think it can be a very big chaos. That's why the most important thing, judicial system has to be respected in order to regulate the dispute. Without respecting the courts, I don't think the people can go ahead. That's where disorders may start in any given state, as long as they have been implementing that. Thank you.
Thank you, Mr. Rugaza. There is one last question directed to Mr. Kipkoge from Nicholas. He asks, Mr. Kipkoge, what are your non-partisan views on the proposed amendments in Kenya to allow manual transmission of results?
Probably I should, the law as he is now is, the results are manual. The results are captured in a form. And even if you are to transcribe those results into an electronic system, you would be doing what Counsel for Iebc in the last presidential petition informed the court that those are merely statistics or data. So as it were, what is being transmitted is a manual results being transmitted electronically. Now, we had a challenge following the determination by the Court of Appeal in the famous Minor KI decision. That decision made two significant determinations which affected the results pathway. The first one is that it said something which was really not new, that results were final at the polling station. I think since 2002, results have been final in Kenya at the polling stations. When the moment that the presiding officer declares the results at that polling station, that is the count and the votes garnered by each party as announced is final. The only thing which remains is aggregation of those results and the announcement of the respective winners by the respective returning officers. So the second thing is that the court in that case declared section 39(2), which is proposed to be repealed now to clean up the law in this amendment, that there are no provisional results. What then used to happen is that after the election has been concluded, the image of the form, it's like taking a selfie sort of yourself, and you send it to the returning officer, so that, and then the returning officer and the public can really see what has happened in all the polling stations across the country. And then subsequently now, you would come with the original form in the form itself. Now it's like bringing yourself, after taking the selfie of yourself, you come, to the tallying center. So at the tallying center, what the returning officer would do is to compare the form with the original form with what had been transmitted earlier. And if they compare well, then he would know that there has been no interference with his result. And then he proceeds to aggregate the results, tally, collect, and announce the winner. Now, the result is always that form, the form in its original format. Now, when it is suggested that you have a different result and it is that image, it is a bit confounding because there is nothing else. So what happens to the form? What happens to the form in the original form? Is it just for record, or what is it for? Now, in the last presidential petition, you may remember what the commission had done was to aggregate those forms at the constituency tallying center and then transmit the aggregated forms to the national tallying center. When the court looked at that process, they said, what have you done with the original forms? They said, you declared the presidential results without verifying. And the verification process entailed looking at the original forms. So basically there is a place for the original forms, and that is the verification exercise. So what constitutes the result is what is transmitted as the image and what has been brought manually by the returning officer. And that is so that you then verify the count. I hope I've answered the question. And that is the intention of the proposed amendments in Parliament, because what was there before was annulled by Justice Chacha Mwita. A debate could be had about the content of the bill itself, and then the Parliament can consider whether or not to improve on it or to change one or two, to allow some transmission, some online portals to be where those forms which have been, the images of the forms can be uploaded to so that Kenyans can see. All those could be included. But I think it's important, especially for those of us who are in Kenya, to know that those amendments to the law are in a reaction to what the court did to the law as it existed before. The court annulled what was there, and what is proposed is to fill up what remains in the law. So I don't know whether you describe that as an unbiased comment. Sorry, there's some noise from my background. There's some construction going on. Yeah, but those would be my comments. Thank you.
Thank you very much. Yes. I'll hand over to Ms. Brenda. Thank you.
Thank you so much. We've come to the end of our webinar. I'd like to thank everyone. I'll start with the panelists. Thank you for joining us this afternoon, for sparing some time and sharing with us on today's discussion. I also want to thank everyone who's tuned in, everyone who's asked a question, everyone who's engaged with us on the chat box. Thank you so much. And we'd like to invite you to join the East Africa Law Society, and the details on how to be a member can be found on the East Africa Law Society website. And just a reminder, the Young Lawyers Committee of the East Africa Law Society normally conduct webinars every month. So tune in, we will be sending you an email on our next webinar session. With that, thank you for joining, and you can